Now, in the latest legal development, social justice activist Dr. Amupanda has been granted leave by Judge Shafimana Ueitele to approach the High Court for further consideration of his constitutional challenge. Now, the case revolves around the contentious veterinary cordon fence separating Namibia's northern and northeastern communal areas from commercial farmland. In the south, joining me in the studio is reporter Daniel Nadunya, to update us on this case. Good afternoon, Daniel. Thank you for joining me.
Thank you, my Leonard host, and it's a pleasure being here.
Right, now first things first, really, it's been a long time coming, since we've had much pronouncements on this case. We're talking about around 2020, 2021. Can you just really give us a brief background of this case?
Yes, this is a case that involves Dr. Amupanda. He's an activist, a social justice activist, who actually is asking the court to declare the veterinary cordon fence, or what has come to be known as the red line, unconstitutional. He argues that it disadvantages majority of Namibian people, especially those living in the northern area of the country and northeast of the country. Basically, he argues it's discriminatory and it disadvantages them. So therefore, it must be declared unconstitutional. You would know that if you have traveled, if you are coming from the northern side of this cordon fence, you are basically subjected to searches where they would basically search to see if you...
Oshivelo side.
Oshivelo side, that side. If you are in possession of any animal product, basically it would be confiscated. And I think in 2021, Amupanda was traveling from the north when his meat was basically confiscated from him, and he felt aggrieved, and he felt that it's necessary for him to basically just challenge the whole legality or constitutionality of that cordon fence. And that is basically the case.
Speaking of the recent applications, it's really centered around, seeking protection under Rule 20 of the High Court, basically looking at costs not having to affect, cases to be pursued, those in particular of public interest. Can you just perhaps expand on that particular issue and what that particular, case entails?
Yes, you would understand that in any legal challenge, especially with civil proceedings, there is always cost involved, because in these proceedings you are basically listing the service of lawyers, and lawyers are not basically doing it pro bono or free of charge. Exactly. Basically, they would require that as they work, you would pay them. Now, what happens is that if you are an applicant in the matter, or whether you are a respondent in a matter, and the court really does not rule in your favor, what would basically happen is that the other party would basically seek for cost order against you. Basically, that you would have to pay your own lawyer, but you also have to pay the cost of the opponent's lawyer, if I have to put it that way. Now, in cases like this, what Rule 20 of the High Court seeks to do is to actually protect people who are actually bringing cases before the court, but these cases should be of public interest. So they should not have fear of litigating or bringing these public interest cases to court for fear of actually suffering this cost order. So that's basically, but there are qualifications to that. For you to be protected or to be insulated in that regard, you basically need to satisfy that, number one, you are unable to afford those costs, and two, that the case that you are bringing before the court is of public interest. And this is actually what happened in this case. Amupanda wants to be protected by the court, to say that in the event that the court is not with him insofar as the merit of the case is concerned, he does not then suffer the damages of cost.
Thank you for that clarity. Now, the case is, is expected to be heard, the status hearing on the 26th of September, really. But considering that this issue dates back from colonial era, what is likely to unfold?
Status hearing that is actually referred to, there is basically still the parties coming together before that judge, and the judge would still have to hear whether there are preliminary issues that needs to be dealt with, and if the status is that the case is ready, then a date will be allocated so that the merit of the case would then be heard, and all matters will be ventilated in that proceeding. Basically, that is what is to happen. But in this regard, the judge then ordered that Mr. or Dr. Amupanda would then have to actually file or expand on his application to prove to the court that indeed he is unable to afford. That may involve also maybe then submitting some kind of financial statement to the court, so that the court can determine whether he is really unable to afford cost of the lawsuit, so that he can then be insulated in that case.
Well, reporter Daniel Nadunya, thank you so much for that insightful update.
It's a pleasure.
It was glad to be your learned presenter.
Thank you so much.
All right. Well, that's it for the news highlight.